Okay, here we are on January 6th, here at the Mercer County Superior Court again. In my case, State versus Forchion, where the state started prosecuting me for a series of marijuana charges from the April 27th arrest. And the funny thing is, the state's whole case relies on a confidential informant, a rat, named Zeb Lapis. But the state won't actually say his name or allow us to subpoena him or anything. And once again, today's argument, this has been the same argument for the last 4 months. The state is arguing that they should not have to give me his name, which is total bullshit. The Sixth Amendment says clearly that I have the right to face my accusers. I'm invoking an entrapment defense, and in an entrapment defense I get to get the confidential informant's name and stuff and say, let me explain an entrapment defense. In my case, I wasn't selling any marijuana, and then the state sent this guy, Zeb, at me, and Zeb came at me, begging me to get some marijuana. And the funny thing is, especially for you racists out there, I want to say this. His excuse to me was, when he came begging me and asking me to help him out with somebody, was because he was white. No one was selling me marijuana, so he was asking me. So here I am, trying not to be a racist, trying to be inclusive, and I help out the pothead, the white pothead. Now look, I'm on the court, this, that, and the other. So next time one of you little assholes out there call me a racist, I'm gonna tell you, ask that Lapis if I'm a racist. He's the rat, and I helped him out, and now I'm all jammed up. He fucked the brother up.
This is the matter of State versus Forchion. Where your first appearance was Katz on the screen.
Good morning, I'm Stephanie Katz on behalf of the city.
Good morning, Your Honor. Edward Heyburn on behalf of the defendant, Edward Forchion, to Mr. Miller.
Good morning, everyone. Please be seated. The record should reflect that I believe there was approval granted from the court floor with respect to the request for the cameras in the courtroom, so we're going to proceed accordingly. Okay, Mr. Boyle, Mr. Katz, this is your motion for protective order.
Thank you, Your Honor.
Well,
Your Honor, the state back in August 2016, specifically August 5th of 2016, returned an indictment with regard to the defendant Edward Forchion. On August 19th, we filed a motion for protective order and supplemented that motion on September 15th, 2016. Basically, we were looking for three very specific things to be protected. Those things are the name of the cooperating witness's likeness, and the address of the cooperating witness.
hold on a second. Name of witness.
The name, the likeness,
Okay.
the name, the likeness, and the address. Those are the three specific things that we requested protective order with regard to. In arguing for that protective order, Judge, specifically we set forth reasons that can be boiled down basically to two things. And rather than go through the entire filing, including that which was a sealed portion of that filing, I would indicate two things that this can be boiled down to are the safety of the cooperating witness and the integrity of the judicial process. Those are the two basic reasons that the state set forth to argue this motion and file the motion back in August of 2016. At that time, the way the motion was filed and the way the motion remains in the court, basically it was set forth by the state. There were three, let's say, levels of protection that were discussed. The first level of protection was the most, I'd say, strict of the three, and that was to protect the name, the likeness, and the address of the cooperator from any production. In other words, the state would not be producing that to anyone at the point when the brief was filed. Again, that was back in August of 2016. The second level of production that was discussed was a gag order, which would require that the state provide some or all of those things. And again, the state seeks to have none of those things provided, but each item has to be evaluated on its own. So the court could determine as to level 2 to release to the defense counsel only with a gag order that did not go any further. One of those things, in other words, the individual's name or a picture of that individual, or 2 of those things, or 3 of those things. And release it to what level? Again, the second level would be to the defense attorney only, not to the defendant. And not to the press, not beyond the defense attorney, not to the public. The third level that was discussed was release those things, again, 1, 2, or 3, depending on the court's ultimate determination, to the defendant and the defense attorney with a gag order as to both individuals, prohibiting any further disclosure of those 3 matters, name, likeness, or address of the defendant. I'm sorry, the cooperating witness. So those are the 3 levels of protection that the state discussed. And in the states, we specifically addressed the fact that we were cognizant of the fact that this would have to be an ongoing process. And the court would, at different times, perhaps revisit the levels of protection. We also made it quite clear that we were not hiding, so to speak, any of the evidence from defense counsel, that certainly defense counsel would have an opportunity to cross-examine this witness at trial, and certainly the evidence of the transactions that occurred would be available to the defense counsel to review. The question was, how would that be done, and at what level would those items be protected? In other words, video. Is the video protected in such a way that the witness's face is blocked out? Is the video protected in such a way that the video is only viewable or audible to the defense counsel and not defendant? Those are all levels that the court would have to address and make a determination with regard to the level of protection that would be granted. Again, the safety of the cooperating witness and the sanctity of the judicial process both have to be considered. While I understand that defense has a job to do and to cross-examine ultimately this witness, the state is in no way seeking to prevent that from happening. It is seeking, though, to protect that cooperator and to protect the process, to not try the case in the public eye, and to not subvert the process so as to either have the cooperator hurt, have the cooperator afraid to testify, convinced not to testify by any number of means, or have the case placed out in the media so much so that it is not triable. The defense counsel responded to the state's filing and basically went through a number of factors, setting forth his reasons that he believed that a protective order would not be appropriate. In essence, Judge, the first argument was a Brady argument. This isn't a question of Brady. We're not talking about exculpatory material. There's no articulation why the information, name, address, and likeness of the cooperating witness is exculpatory in any way. So I submit that Brady doesn't apply. With regard to the Sixth Amendment right to confrontation, Your Honor, I've already addressed that. The defendant will have an opportunity to cross-examine the cooperating witness at trial, so there is no Sixth Amendment argument as to these factors. With regard to the informant's privilege, Judge, informant's privilege is not applicable in this matter. We're not seeking to use the informant's privilege. We're following Rule 313-3E, which is a protective order. It's a discovery motion. It is not an informant's privilege. Granted, Your Honor, some of the case law ultimately falls back on the same reasonings. In other words, the protection of a cooperator, the safety of the cooperator, and the integrity of the judicial process. But ultimately, the state filed a protective order motion under 313-3E. With regard to the defendant's argument that a protective order should not be granted because the defendant needs to file an affirmative defense of entrapment and can't do that, again, there's no articulation as to why the name, address, and likeness of the defense, the cooperator to the defense would enable that in any way different than the discovery that has already been provided. In fact, Your Honor, it seems to me in reviewing defense counsel's argument, he's already laying out his reasoning for believing that he has an entrapment defense to file. He's done that in his paper so far. Granted, this is not what we're arguing today, but clearly in reading the statement of facts set forth, it's clear to see where the defendant is going, and he's spoken quite frankly about that, indicating he wanted to file an entrapment defense, and you can see that lining up in his statement of facts. With regard to this case as a whole, Judge, we have been concerned from day one about the safety of our cooperator. We're always concerned about witnesses, whether they're cooperating witnesses or eyewitnesses to criminal matters. In this day and age, that should be no surprise to anybody. People are afraid to come forward, and when people do come forward, there are all sorts of concerns for their safety. So that is always a concern for the state. And from day one, this defendant has sought to put that cooperator's information out in the public to tell people, hey, look, there's a cooperator in my case, go find him. There's a cooperator in my case, this is who I think it is, here's where he lives, here's who his wife is, here's all about his children, here's where his wife works. With absolutely no knowledge of whether that is the cooperator. Assume it's not the cooperator, and this person is being attacked publicly on numerous social media sites and in traditional media. Clearly there's a danger to this particular person and that particular person's family. Despite the fact that this motion was filed in August, Judge, despite the fact that the motion was pending, the defendant continually, over and over again, placed information in the public eye, social media, and traditional media, with regard to one particular individual who he believed was the cooperator, with knowing that this motion was filed, knowing that the court was going to make this decision, but basically trying to subvert the process. And what did he say? Often, over and over again, in all of these public postings, he said, I don't care what the judge says, I'm going to do it anyway. I don't care if there's a gag order, I go and do it anyway. Over and over, to the press and on his social media videos. And he did that, Judge, despite the fact that this motion was pending. Doing that, Judge, not only subverts the process, but makes it very clear to the court, the state would argue, certainly makes it clear to the state that the defendant is going to do what the defendant wants to do regardless of how this court rules, and that is a great concern, number one. The secondary part of that, Judge, is in response to this, after the court ruled with regard to how the attachments to the briefs had to be filed, with regard to the gag order, defense counsel responded. And in his filing, he placed the same name in public documents, photographs of the same person, and additionally, all types of background information on the person that are completely irrelevant, not only to this case, but to any case. And placed them in public filing despite the fact that there was a gag order signed as to attachments and how I was supposed to provide the attachments. So he takes the same attachments and puts them in his brief. That's a concern, okay? I understand he's representing his client, but I have to still be concerned for the safety of anybody, whether it's the cooperator or it's not the cooperator, this person's name is now out there, okay? If it's not the cooperator, someone's in danger. If it is the cooperator, someone's in danger. It doesn't matter. They're putting this name out there saying, we know who it is, his name's already out there. They put the name out there believing that that's who it is. And quite frankly, Judge, this type of motion is generally made, a lot was said to the fact that we made this motion initially under seal. There's a reason for that. Again, because we're trying to protect people. We're trying to protect the sanctity of the case, and we're trying to protect the cooperator. With regard to I made a quick mention of some of the facts that were set forth in defense counsel's brief. Quite frankly, Judge, I don't think the facts of this case at this motion are relevant in terms of did the defendant distribute, did the defendant not distribute, because we're not there yet. We're not arguing the facts of the case. We're simply arguing the protective order with regard to the witness. But I do think that there's one thing that needs to be addressed with regard to that, and that is this. In the defense filing, there's some description of an event that is relayed in a police report dated March 14, 2016. There's an indication in defense counsel's brief that he attached the police report of that event. And in that event, in that description of the event, he basically indicates the beginning of the event and then moves to the next date. I think it was March 22nd was the next event, March 15th. In any event, Judge, he says there was no distribution. He doesn't provide the police report, even though he said he was providing the police report. He provided another police report. The police report from March 14th specifically talks about the distribution that occurred, $300 distribution that occurred at the defendant's hand to the cooperating witness. So for purpose of completeness, Judge, I know we're not arguing the facts, and I'm not here to argue the facts, but I think that the court needs to see that police report in light of the fact, just so that everything is complete. I brought a copy for the court. It might just have been mistakenly left out by defense counsel, but because it's alluded to as an exhibit, but it is not an exhibit in the brief, I did bring a copy of that for the court. And
I have no objection to the
This is,
I just want to see unless Mr. Heyburn.
Right.
no, I know, I'm showing him. And like I said, it may have been left out accidentally, but I did bring it because I noticed that it was left out when I reviewed the process.
Yes, this should have been attached, Judge.
Okay, just give it to the officer. Anything else, Ms. Katz?
Yes, Your Honor. In sum, I would indicate that the argument of the defense does not ever articulate any facts to support its position that a protective order should not be provided, that a protective order is not necessary. If anything, quite frankly, I would indicate that his filing bolsters the state's position that a protective order is needed. There is a continued danger to any witnesses, certainly anyone the defense believes to be witnesses. There's a clear attempt in this case to go after someone that the defense believes is a witness, and I think the only way to protect this process and that the cooperator and the particular person that have been named, Judge, is to provide for a protective order without your statements.
Hold on, Mr. Chairman, one question. On your original protective order that you filed, there was a portion of that was a legal argument that Mr. Heyburn wanted, okay? And it really wasn't factual. I did order that released in the paper because there were additional pages that were purely a legal argument, no disclosure of the witness, nothing, cooperating witness, nothing else. So Mr. Heyburn got that. I thought that was appropriate to give to you, Mr. Heyburn. Okay? I just want to make that clear.
Judge, I don't remember it happening that way. I remember Your Honor indicating that I would get a redacted brief,
Right.
and then Your Honor would decide. I never got a redacted brief. I got an alternate version. So I never got anything from the
Everything you got was you got all of the legal arguments.
Okay.
That's what you got.
And then just for clarification purposes, what I did for the record was what Your Honor requested I provided to the court a black line version and then provided the redacted version. So what
I think the
defense counsel...
difference is maybe a page.
I'm sorry?
I think the difference in what...
It may not even be that long.
Not even that long.
But in any event, just so the redacted version, I didn't write redacted on it, but just so the...
But I was concerned that Mr. Heyburn has to complete the legal argument.
He does, Your Honor, and that was provided for court order, I think it was, I want to say October 25th, but
Okay,
I'm not that.
thank you. And on the December 20th submittal, Mr. Heyburn has that now. Okay?
Yes.
All right.
I checked. I never received the attachments based on a signing of the consent order.
Okay. On the December 20th submittal?
Correct.
Okay.
Your Honor, the attachments were provided pursuant to...
Oh, I'm sorry. The supplemental brief.
Right.
And let me ask you a question, a supplemental brief, before Mr. Heyburn addresses the court. Page 4. As such, measures can be taken to allow the defendant to redact a copy of the video, record a transaction so they can prepare whatever defense they desire. And the sentence above that, simply put, the state is seeking an order which will restrict only the providing of the cooperating witness's name, address, and likeness to the defense.
Correct.
So in essence, you're proposing, Mr. Heyburn, that his address, name, and likeness, but you would provide to him the actual transaction.
Correct, generally, we'd have to go take that video to McLaughlin or one of those facilities and have that blacked out. And again, we'd ask that regardless, even if that were to happen, that would be specifically provided in a particular manner, so it's not all over the entire internet and all over the
To
entire...
Mr. Heyburn and Mr. Forchion?
Well, Judge, I request even if we're going to do that, it would go to Mr. Heyburn only. Mr. Forchion doesn't care. He's already indicated he's going to do what he's going to do. No, he's going to do what he's going to do. He does care. He should care. It's his case. But what I'm saying is, if Your Honor is going to tell him not to do something, he's going to do it anyway. We've already seen that when his counsel told him not to approach me, and we walked out of the courtroom. I got 2 emails as soon as we walked out.
Okay,
So he does what he
let's
wants.
focus on the facts. Mr. Heyburn.
Judge,
So it's clear, the video we're talking about is my client's video. Okay, he operates a sandwich deli luncheonette, and he has a surveillance video And the state sees my client's video. And now they don't want to turn that over to
Is it an internal video or internal and external?
It's internal and external.
Okay, so it's internal.
And the state doesn't want to turn over my client's video without redacting it. So it's not something that they produced and they want to redact it. They want to withhold that. But we've identified one of the factors that the court's to consider on granting these orders is if the person's, this confidential witness or informant or whatever it is, whether his name has already been revealed. Okay?
That's a question. Do you know who the witness is?
Yes, and we named him in our brief. It's Zeb Lapidus, and I'll explain to you why that's particularly important. One, Zeb Lapidus, in terms of my research, has multiple arrests that can only be the arrest. I'm trying to select my words carefully. He has multiple arrests for fraud-related
No, don't
incidents.
object, because here's what we were.
It was already in my brief.
And it shouldn't have been in the.
You know who it is. Isn't the opposition to the protective order moot, or is it still valid?
No, the problem is the state has withheld all discovery from that point on. Okay, so I mean I know who the witness is. I know where he lives. I understand that my client has posted this on the internet. As I've read it, he's asked for information about him and asked people not to harm him. And the information we got back was extraordinary. I have so much to cross-examine this person because there were various offenses, and in fact, he's being sentenced in municipal court today. So the internet was used, and I don't want to sound like Donald Trump, but the internet was used to collect information from the masses, and it was absolutely incredible. So I know now about a number of scams that he's pulled locally, arrests.
Here we are again. The point is, there's been no indication here.
It's public knowledge, that's what his argument is.
Right.
But Judge, let's be fair about this. This particular person he's naming is public knowledge. Nobody has ever said, because there's a protective order out there, whether that is the correct person
So
or
that
not.
was your,
So
that was your argument initially, whether it is or is not.
It's because if I, Judge, let's
Judge, man,
walk
this is my
through it.
argument. It's just disrespectful.
This is a very important argument. Let's both take a step back. Her argument initially was, if you disclose it, there's going to be a problem. Okay? And you're indicating that you know who it is, okay? And maybe it's not that person. I don't know, okay? So why don't we keep this, why don't we just argue the legal issues? I understand your argument.
Obviously, one of the factors is...
Yeah, I understand what your factors are, and I think you set forth in your brief.
Right. And, but just so that the transaction is on the record, typically these cases come forward where a confidential informant gives a tip to the police, then the police then use that as probable cause, and then their investigation ensues, and they make arrest. But here, it isn't that type of confidential informant. Based on the police reports, this is somebody that the police sent in to make these alleged transactions. Cooperating witness. But this is somebody, and the state's brief initial motion was so that I couldn't even have access to a video of the transaction or have copies of the audio portion from where this witness was recorded during these transactions. The issue is, if I am going to lay out an entrapment defense, I obviously need all the audios. I also need the identity of this witness because I will need to go back through hours and hours of videos to see any other times that he approached my clients and any other witnesses. Because that would clearly bolster an entrapment defense if this cooperating witness was approaching people and randomly just asking, hey, I have a lot of money, can I buy drugs? What can you do? And then he just went down the line of people. So I have a right to see his identity so I can go through all the other times that he approached, and then also so that I can use him to cooperate. Unless the court's willing to say, to the state, listen, he's like a typical confidential informant. None of his testimony is going to come in. If Mr. Heyburn can't get it, you can't use it against his client. Anything from that witness is barred. But what they're saying is they're more than happy to produce him at the time of trial, and at the time of trial, I can get this information and cross-examine him. But I can't do an investigation up to that point. I can't use his, I can't even see his likeness so that I could then compare him to the other portions of the videotape. It's just going to hamstring me. Now, my client has never been charged with a violent crime. There's never been a threat, and this individual's name has been out there for the better part of last year. And as far as I know, there hasn't been any harassment of this particular individual. With respect to Ms. Katz's argument that she read something on the internet where my client said he wouldn't obey this court's order, well, if my client, if Your Honor makes a ruling and an order and my client doesn't obey it, well, then you put him in jail, and then that cuts off his internet access. And he's a big boy, and he has to understand that that's what the rules are. Okay, but I have to defend my client at the end of the day, and I need to see who this person is. I need to hear what he said, and I need to be able to collect information. I need to be able to send out subpoenas. I have a whole host of witnesses that have information on this individual. I have to collect certified court dispositions. Am I going to be prohibited from putting his name on a subpoena? It's gotten to be absurd, and the Mercer County Prosecutor's Office in every single case argues that their witnesses have to be protected, and that is against the way trials work under our Constitution. We have public trials. Okay, Ms. Katz wants to see a system where everything is tried, where the defendants don't have the information, and there are secret aspects. That is a Brady violation. This is the type of case. If Ms. Katz leads Your Honor down that direction, we might as well just start out with the appellate division, because it's going to end up in a bad case. The defendant has an absolute right, and there is videotapes. So it's gotten absolutely absurd at this point. So I would ask that the court deny Ms. Katz's application for a protective order. This person's name is out there in the public domain. There's nothing that this court's going to do that will unring that bell, and that's just how the internet works. And Ms. Katz suggested that there was a protective order prohibiting me from filing anything with the client's name. There was no protective order. Recently I signed a protective order for the sole purpose of getting exhibits, which Ms. Katz never produced to me. So there was no protective order. I could say his name 100 times.
Let me ask you a question. Has there been a document filed regarding an entrapment defense?
No, I haven't, but I haven't received most of the discovery. Judge, I haven't even received the drug test. Okay, I haven't even been able to see. So there are no lab results. There are no lab reports to say that what they collected was even marijuana. Okay, Ms. Katz hasn't produced that. There's so much.
So those have been produced. There are two packets that were produced. I can tell you the exact lab when they were sent out. There were 2 different packets sent. I know there's an issue with Mr. Heyburn mail, but we have received back that those have been received.
Why don't you just give him a hard copy so he has it?
I don't have them with me, Judge, but they've been provided. In fact, it's a full lab packet, not just a lab test.
I've gone through everything, Judge. There was one issue where I didn't pick up certified mail, and I picked it up at Ms. Katz's office. None of that had anything to do with lab results. Okay. But again, your Judge, it's just my client should have his videos back so he can defend himself.
Do you have any of those videos back?
No, they haven't produced.
From the state police?
No, not only have I not had the videos, they wouldn't even let me go there and see how they were, because there's an issue. There were in addition to the DVRs, there were 2 hard drives, And now the state says, oh, you know what, there's just, our evidence sheet only shows there's one hard drive. So now one's missing, and that was our concern from the get-go. From Jump Street, we filed a motion to return the property because we were afraid that the state was going to destroy some of this information. And then sure enough, when we get the evidence sheet, only one hard drive shows up. And I've asked for permission to go and at least view the casings. I haven't even been allowed to view the outside of the videotape. I've been kept so far away from this evidence, I might as well argue it from the other court.
State police, have you supplied Mr. Heyburn with all of this stuff?
I don't have it back in the state police yet, Judge.
Okay, when's it going to come back to the state?
Well, we provided them the hard drives that they require to make all the copies, they're making the copies, but quite frankly, Judge, until there's a court ruling, I don't know how to provide it, and we've indicated to the court that certain rules require that we provide evidence, make it available for him to come see it.
I think Judge Warshaw addressed this initially, addressed part of this, but the last time we were here, there was supposed to be discovery changed. I believe the state police was supposed to give you the documentation back to give to Mr. Heyburn.
I don't have it. Judge, unfortunately, forensics takes some time. We're not the only county that provides hard drives for them to copy. There's a tremendous amount of evidence on this. Once they take it from us, I don't have control over it. I can tell you now, Judge, there are homicide cases where we're still waiting for surveillance video. They are dealing with the entire state.
Tell Mr. Heyburn.
Right. I've asked for permission to let me call and find out. Okay?
We called as early as...
But no, Ms. Katz always says, and if you look back, by November 1st she'll have it, then November 7th, then November 14th, and then we never get this information. I should be allowed to go to, just like I go to any prosecutor's office or any police station, and they should be able to show me what the evidence is. Okay?
And we have no problem with that, Judge, once the ruling is made and once we have it in our possession. The lab, I can't get into the lab to watch it. At this point, what they're doing, Judge, is they're making, it's a lab. They're making their copies. They have a million other things that are going on. We called as recently as this morning. I'm trying to get
But the
information.
ruling only has to do with the cooperating witnesses' identity, address, and letters.
Which is on the video, Judge.
Judge, I'm not...
But how many witnesses is on?
I don't, Judge, it's,
You don't have,
I don't have, the videos, but Judge, the videos are hours and hours, days and days and months. So quite frankly, Judge, we have to...
Ms. Katz is arguing a point that I'm not raising. What I'm saying is this, okay? I'm not saying that, of course, they're not, I think they'll take it up on appeal before they let me see this video. What I'm saying is there are physical pieces of evidence. There are multiple DVRs. Hard drives are multiple hard drives. I assume bags of marijuana, a bag of money. Why can't I go in and take my own inventory and see what there is? Okay? The last time I was told, Ms. Katz said, oh, because of the way they have it hooked up. I think this is bonkers. Now, I'm a little bit more tech savvy than perhaps the average practitioner, but I could have copied those videos inside a few hours. Okay? You hook up one computer to the other and a blank hard drive, and you just copy it, whether a DVR or a hard drive. I just can't believe that the state police without, well, I can't believe the state police are going to take about a year to copy these, no matter how busy they are. So I just don't, I'm incredulous when it comes to Ms. Katz's representations.
Ms. Katz,
Yeah, quite frankly, my tech knowledge is limited, but I can tell you that based on what we were told and how the copying needs to be made, there is a huge amount of evidence. They're doing the best they can. I never ever told Mr. Heyburn that he couldn't see the rest of the evidence. The physical evidence that at the lab I don't have access to. He wants to see the marijuana.
So what can you see?
He can see everything I have. It can be brought, that evidence can be brought to our Lamberton Road office and that can be set up. I've never said that can't happen. The physical, when he wants to see the hard drives, I don't have it. I can't see it. And certainly there's going to come a point when Your Honor is going to make rulings with regard to how this evidence is
I'll
provided.
make a ruling within 10 days.
So, and at that point we'll know what we're doing.
It's going to take me 10 days to get the ruling. Okay? It's important, it has to get done. I believe Judge Warshaw initially denied one motion.
I had, what happened is pre-indictment, I had filed a motion to return property, and then there was an indictment, and then on the record, the judge said, well, you're going to have to file a motion to attack the affidavit.
That was initially.
So that's why we're here.
So in essence, I can tell you, I will submit something to you. 10, 12 days, I'll do a record date for you.
Okay.
Okay, the reason is you're going to need it for future use, okay, one way or the other, or somebody's gonna both your many meetings, so I'll provide it if you need something, okay?
Thank you.
You're welcome.
Thank you, Judge.
You're welcome.
I should just indicate for the record, I know that there was a question, did you get the attachments when the law clerk gave you the brief?
Yes.
Okay, because again,